Hey everyone. I know I promised you a couple crazy long videos. I haven't got those done yet. And I wanted to sneak this one in because while there's no flaming dumpsters or, fires to put out, this one's kind of interesting. It's a homeowner who hired a contractor. Imagine that. Things went wrong. Imagine that. Because of the contract. What's our rule? Always have a contract with everything on it. The interesting part about this, though, is that she does it all pro se. And she does pretty good, in my opinion. I mean, compared to what we see on a daily basis. So I can't send you to court because I don't have the original video because this took place in 2017 in Dixon County, Tennessee. Usually when we're in Dixon County, we are in the courtroom of Judge David Wolf watching some kind of craziness unfold in there. However, this was next door in Judge Wallace's courtroom. Now, Miss Clark hired Mr. Givens to do some renovations around her house. She wanted some cabinets fixed, paint the walls, replace the countertop, a couple minor things. No big deal. They agreed to do that, and he started the work. Now, what Miss Clark didn't know is that Mr. Givens had several health conditions that kind of limited his ability to perform physical activities. I'm not really sure. They didn't really get into details, but apparently it caused some issues in him getting this completed. Ms. Clark was not happy with that, and she said, okay, I'm going to hire somebody else to finish this out. She ended up suing him and his wife under the Tennessee Consumer Protection Act. Now, Mr. Givens and Miss Givens in turn sued Ms. Clark for breach of contract. So all of this went in front of Judge Wallace. And back in 2017, Judge Wallace determined that the contract was not valid. He rescinded the contract, and he found that they made a mutual mistake in setting the contract because there was no length of the contract term provided. He dismissed both parties' claims. Both parties appealed. And so now we're going to the Court of Appeals of Tennessee at Nashville, where Miss Julie Clark is appearing pro se with Mr. Jeffrey Givens, who has an attorney. Now, I just want to give you just a really quick background about Miss Clark. It's actually Dr. Clark. She grew up in Texas, real country girl. And she has a website, so she told this story on her website. So I'm not stealing, I'm not divulging any crazy personal information that's not already out there. I don't usually give you personal information about these people because this is their private life, and you wouldn't want your private life spilled out there, but she has put this out there herself. So it's a really cute story, and I kind of like it. She went to a music festival back in the 70s. I guess they used to be called pop festivals. I'm not sure because they didn't call it pop music back then, right? Somebody tell me. I'm an 80s baby. So she had her dogs with her, and one of her dogs got sick. So the teaching hospital veterinary, I can't remember the name of it, was right up the street. So she went over there, and she said when she walked in the door, it was like she instantly knew this is my path in life. I need to be a veterinarian and take care of animals. Kind of cool. So she went to school to become a veterinarian, and when she graduated, her mother was from California and had always talked about how much she loved California compared to Texas. And she and her mother decided to move back, so she loaded up her car with her 17 cats, her 70-pound dog, 2 bird cages, and her mom, and headed back to California. I can picture that in my head. Like, I feel like I have done this with a kid or two added in. I don't know. Minus the birds. I don't do birds. Oof, birds. Anyways, so we are in the appeals court for Tennessee to hear the appeal from Judge Wallace, who has canceled the contract, reversing the prior order, and remanding it back for further proceedings.
Golden from Memphis, and I'll be presiding this afternoon. I want to welcome you to the afternoon session of the Court of Appeals. Joining me on the panel today are Judge Judge Armstrong from Memphis, and Judge McGee from Savannah. We have very few rules here, but I wanted to alert you to the fact. I think Dr. Clark, you'll be representing yourself as the appellant, and you're entitled to 5 minutes, up to 5 minutes of rebuttal if you would like that, and you can let us know after you've identified yourself when the case is called to the docket. And of course, as appellee, you get 15 minutes. So, Mr. Hivner, if you please call the docket.
Julie Clark versus Jeffrey Givens et al.
Dr. Clark, you ready?
I am, sir.
Are you? Please identify yourself and let us know if you'd like to reserve any rebuttal time.
My name is Dr. Julie Clark, and I'm going to reserve 1 minute of rebuttal time.
All right, 1 minute. You may begin.
Well, let me say good afternoon to begin with. I have struggled with what to cram into this 15 minutes, so I'm going to basically give a review of the intentional misrepresentation that I encountered in this case. Judge Lawrence Wallace presided over the trial case last May 7th of 2019. And despite Judge Wallace's characterization that this case was difficult beyond what he had even anticipated, I believe the case can be boiled down to one statement that was made on behalf of Jeff Givens, the defendant. When I asked Mr. Givens, did he not think that I had a right to know that he was disabled before I hired him? His response to me was, well, ma'am, if I'd have told you, you wouldn't have hired me. That statement smacks of intentional misrepresentation. When I met Mr. Givens, I had no idea that he was disabled. He did not look disabled. I only learned of his disabilities when he started using those disabilities as excuses as to why he was not showing up to work at my vacated home in Kingston Springs that I was fixing up to sell. When he started speaking to me about those disabilities after the fact of our contract, he went into great detail how he had been injured in 2011, had broken his left arm, but he explained that most of his disability had come from what he considered a botched synovial nerve block in his neck. And he said he had excruciating pain from his hand up into his shoulder and neck that was unrelenting. He said he had debilitating headaches several times a week. He also said that he had trouble seeing out of his left eye, which he used as an excuse to explain why the paint line going along the junction of the ceiling and wall along my stairwell was completely wobbly and crooked. When I learned of Mr. Givens, it was through my daughter, who was a special education teacher at Harpeth Middle School in Kingston Springs. Her classroom happened to be directly next to the daycare, which was run by Mr. Givens' wife, Wanda Givens. My daughter would spend lunchtime with my grandson, and she noticed Mr. Givens working and doing various carpentry type things at the daycare. She said, well, maybe, Mr. Givens might be able to do some work for you, because she knew how much difficulty I was having finding good workers in a housing boom. I mean, I couldn't get even the qualified workers to return my phone calls. So in January of 2016, when I went to pick up my grandson, I asked Mrs. Givens, does your husband do work for individuals other than the Cheatham County School District? And instead of telling me what she told Liberty Mutual a mere 3.5 months earlier, I neglected to mention that when Mr. Givens told me about his disabilities, he also told me that he was in the middle of a workers' compensation suit with Liberty Mutual against his employer where he was injured. And so both him and Mrs. Givens gave depositions in that workers' compensation suit. Well, in September of 2015, like I said, 3 months before she told me that Mr. Givens could do anything that I wanted him to do, she told Liberty Mutual that Mr. Givens could only use his left arm as a prop. He had not worked since 2011. He sat around the house, couldn't even mow the lawn, but she told me that he could do anything that I wanted him to do. And she specifically named 4 categories: carpentry, electrical, plumbing, and HVAC. It's clear that Mr. and Mrs. Givens meet the criteria for fraud. Both Mr. and Mrs. Givens made a representation to me as concerned Mr. Givens' physical capabilities, and Mr. Givens went a step further when he told me he was an experienced painter. Secondly, both Mr. and Mrs. Givens knew that these were false statements because they had made statements to the contrary to Liberty Mutual. Thirdly, they used these representations to induce me to hire Mr. Givens. I was so induced, and finally, I suffered damages as a consequence. This simply could have been a he said, she said case if it wasn't for those depositions. When I went to General Sessions, I know nothing about the law before this. I knew nothing, I should say. I didn't know what pro se was. And I had never sued anyone in my life, not since and before, despite the fact that I had a veterinary clinic in Camarillo, California, built from scratch, according to my design, that I've owned 6 homes that I've maintained and improved. I was a sole practitioner in that clinic for 17 years, maintaining it. My father was in construction. I know something about construction, but I've never sued anyone. But when I found out about these depositions, I was shocked. And when Mr. Givens gave his deposition in July of 2014, he went much further than what even Mrs. Givens said. He said that his condition was not improving. It was getting worse every year, that he went on to repeat that he was in pain from his arm.
Clark, I have a question. Are these depositions in the record?
They are. In the trial court, by the time I went to the circuit court, I was able to get those depositions with a proper certificate of service. Man, I know what a certificate of service is now.
My question, though, is have they been admitted into evidence in this case?
They, oddly enough, I tried to get them and they weren't, they acted like they weren't going to give those to you for some reason, but they are referred.
Listen to my question. Were these depositions admitted into evidence by this judge in this case? Are they part of the record on this appeal?
They are part of the record.
Okay, were they admitted into evidence?
Yes. I mean, that could have been a mistake on my part. I used those documents throughout the entire trial and referred to them constantly.
Well,
but I don't know if
copies of those depositions in this record that we're going to review.
Repeat that, sir.
Are copies of those depositions in the record that we're?
They are not. But
Okay.
I refer to them in detail in the record that you do have, the court transcript.
Is there testimony from those depositions?
Absolutely.
In the court transcript?
Absolutely. Plentiful.
All right. Go ahead.
Yes. So, being pro se, I may have not entered those in as I probably should have, such that they came to you. I didn't understand why they didn't come to you, but they are in the transcript. So as I was mentioning, Mr. Givens, in his testimony to Liberty Mutual, said that his condition was only getting worse. He was in constant pain. He had to hold his left arm against his chest at all times. He went on to other things that he had not told me. In addition to the headaches and not being able to see out of his left eye, he said he couldn't tolerate hot and cold. He had skin conditions. He had heart palpitations. It went on and on. And so as a result of that Liberty Mutual workers' compensation case, Mr. Givens was awarded $170,000 in February of 2017. And he was declared 71% permanent partial disability as pertains to his body. So I was baffled when Judge Wallace made his ruling. I feel Judge Wallace erred in not acknowledging the intentional misrepresentation on the part of both Mr. and Mrs. Givens, and the fact that he didn't use the Tennessee Consumer Protection Act when it was warranted. In the Tennessee Protection Act, 47-18-104B number 7, it states that it is unlawful to represent goods or services as being of one standard, quality, or grade when they are of another. Both Mr. and Mrs. Givens definitely fulfill that violation. It also states in 47-18-109A1 that when someone sustains damages as a result of the previous violation or any violations in Part B, that an individual can take action to recover those damages. And that was my entire case from day one. I have not changed my entire stance all along. On the other hand, Mr. Koppel, the attorney for the defendants, has never once addressed the intentional misrepresentation perpetrated by his clients, never talked about it. He has never once spoken to the fact that Mr. Givens is a sorely inexperienced painter. When Mr. Givens' exact words to me is that I've done lots of painting, I'm a great painter. And what Mr. Koppel bases his entire case upon is portraying me as breaching the contract as a result of custom built homes versus McNamara, where 4 criteria are listed as a way to lawfully terminate a contract. Mr. Koppel says that Mr. Givens doesn't meet any of those, when in actuality, Mr. Givens meets all of them. He was unable to complete the contract physically. He showed an intent to abandon the contract. He repeatedly did not show up to work. I was busy working at the time, and I would come check on the house, and not anything would have been done from one week to the next. And that's when he started telling me he had all his problems. He also appeared to no longer be bound by the contract. And most importantly, he committed fraud. I don't feel that it's appropriate to even speak of a breach of contract in this case, because there can be no meeting of the minds. There can be no contract when one party has been severely, material information has been severely omitted, willingly and with a forethought. So I am asking this court with all my heart, because this has been a long 4.5 years, to hold Mr. and Mrs. Givens accountable for their violation of the Tennessee Consumer Protection Act 47-18-104B Part 7, to award treble damages because their violation was willful and knowing, as is stated in 47-18-109A3, and to award the attorney's fees and costs for the trial court, as is recommended in 47-18-104E1. And finally, there are no attorney's fees in the appellate case, but to award me the substantial appellate costs, because I had to pay for the transcript and of course the fees to file the appellate case. But those appellate costs are recommended to be offered to a Tennessee Consumer Protection Act individual in Killingsworth versus Ted Russell Ford, Inc. Finally, I want to just quickly read a statement by Justice Warren D. Wolfson. Justice Wolfson says, we still understand hard-won rights can be lost simply by taking them for granted. We are reminded every day that we function in a public place where truth is truth and lies are lies, where people who act must be held accountable, and where the state is held to certain standards. We don't need more laws and higher penalties. We need vigilance. I thank you.
Thank you, ma'am. You'll have your 1 minute left after Mr. Koppel argues.
Thank you, sir.
Mr. Koppel? your audio's not on.
I apologize. Thank you, Your Honors, and good afternoon. May it please the court, I am George Koppel of Nashville, representing Jeff Givens and Wanda Givens in this case. In this case, the trial court dismissed the suit for breach of contract. And I will refer to my client sometimes as Contractor. He's an independent contractor. That's clear. It's not disputed that he was not an employee. It's in the record that Ms. Clark admitted that he was an independent contractor. And I will sometimes refer to her as the owner. So what we have is a small construction contract here. It's verbal. It's for doing a lot of painting and some maintenance and repairs, miscellaneous things to get her house in shape to be put on the market. The contract was reached verbally between the parties in January of 2019. And the reason that the trial court gave for dismissing rescinding the contract and dismissing my client's claim, the contractor's claim for breach of contract, was what the trial court called mutual mistake. And what mutual mistake was the trial court pointing to? The trial court said that the parties' failure to arrive at an agreed time of completion was a mutual mistake. Now, I'll come back to the mutual mistake. That's what the trial court ruled. He didn't rule on any of the stuff that Ms. Clark talked about. That was his ruling. And he rescinded the contract and dismissed both parties' claims for breach of contract on the grounds of mutual mistake. And we'll come back to that. Now, a time of completion clause is simply a clause in a construction contract in which the parties agree that the contract will be completed, the work will be completed by a certain date or within a certain number of days or weeks or months. It is not required. It is common for tradesmen and small contractors to talk with homeowners and to agree to do any number of things: painting, carpentry work, plumbing work, electrical work, and they reach a verbal contract. It is not required that you have a time of completion clause. Now, time of the essence clause. A time of the essence clause is a clause in which the parties explicitly agree to the phrase, time is of the essence in this contract. Or in this contract, the parties hereby agree that time shall be of the essence. It has to say essentially that. And the significance of it is that without a time of the essence clause, slow or delayed work, not finishing in time, going past a deadline, is not a material breach of contract. It is not a material breach of contract to violate a time of completion clause unless you have a time of the essence clause. And my authority for that is set forth on pages 14 and 15 of our brief. Madden Phillips Construction Company versus GGAT Development Corporation, a 2009 opinion of the Court of Appeals, and it's a reported decision. That case holds that, quote, a party's failure to complete a construction project within a time for completion does not constitute a material breach absent a provision making time of the essence. And that case cited and relied on a 1998 Court of Appeals opinion, also a reported decision. This is on page 14 of our brief, which was Shepard versus Perkins Builders, holding, quote, generally time is not of the essence of a building and construction contract. So what the court did was the court erroneously, and this is purely a question of law.
Mr. Koppel, let me ask you this.
Yes, Your Honor.
Does that mean that it could take an indefinite period of time to complete the contract? Is there any limit on the time that your client would have had to complete the contract?
She would have remedies, Your Honor, but she wouldn't have the remedy of terminating the contract. And that is correct. And of course, that's the reason that lawyers would recommend that they enter into written contracts. But that is the law. And I have not been able to find any discussion that said, well, you know, if it got to be, as you say, 4 months, you know, it's supposed to be 2 weeks and it's now 4 months, or it's supposed to be 2 months and it's now a year. I haven't found any cases that, you know, talk to that kind of extreme situation. But in this case, it's admitted that the parties did not agree. They did not reach agreement. So not only did they not have a time of the essence clause, they didn't have a time of completion clause, not one that they had agreed to. Now,
well, let me ask you this.
Yes, Your Honor.
Was your client aware that Dr. Clark that the purpose for which he was being hired was to get this house ready to be put on the market?
Yes. And what the record shows, Your Honor, is that in their discussions, she testified. Again, there's no proof of this. There's nothing in writing. She testified that she told him she wanted it done in 2 weeks. He testified that he estimated 4 to 6 weeks, but he did not guarantee that it would be completed within 4 to 6 weeks. And the judge made no finding that either one of them was more credible than the other with regard to that or any other issue. So we have a situation in which there is no time of completion clause, and certainly no time of the essence clause. And I don't want to take up too much time on this, but you know, if Your Honors will think about it, I'll bet that none of us have ever seen in our entire lives a verbal contract between two non-lawyers where the homeowner is not a lawyer and the contractor is not a lawyer. They're just normal homeowner and tradesperson acting as an independent contractor, in which either one of them even came close to saying, oh, by the way, can we agree that time is of the essence in this contract? That's just never happened. If you're ever going to have a time of the essence clause, it's going to be in a written contract. And this was clearly, all that happened is she told him what she wanted. He did some calculating and came back in 15 minutes and said, I can do it for this amount. And she said, okay, when can you start? That was the contract.
Did they reach an agreement about the contract amount?
Yes. It's 11,500 and I'm sorry. 11,000. And she paid 4,500, Your Honor, and that left our total claim at 7,075. And I apologize, I have to add that in my head. That'd be 11,575 was the contract amount.
Did Dr. Clark agree that that was a contract amount?
Yes.
Or did she testify that it was a lower amount?
Here's what happened. Her testimony was that there were certain items that Mr. Givens testified were part of the contract that she said, I didn't agree to that. I talked with you about it. I told you about it. I told you I'd probably want you to do it, but I wanted to hold off until I saw how you did on the painting part of the contract. So her position at trial was not that the 11,575 is an erroneous number, but rather that only about 9,000 of it was actually contracted for, and the rest was to be contracted for. So that's the full answer to your question. But see, it's important to remember, Your Honor, and all of Your Honors, The judge made no findings on any of these things. He made no findings or conclusions as to anything that Ms. Clark said in her presentation. He made no findings as to the scope of the contract. What he found was that by not agreeing to a clause for time of completion, that they had made a mutual mistake. So let me go on with the rest of that, so I don't run out of time.
Why would that necessarily be a mutual mistake? In other words, if you have an oral contract like that, why wouldn't you make a determination as to whether or not that it was a reasonable time? What would be a reasonable time for the contract to be completed?
Exactly, Your Honor. But you see, let me tell you what the law says a mutual mistake means. I'm going to give you two examples. These are from Sikora versus Vanderplug, which is a reported case from 2006. And here's a good example. Let's say there's a house that's going to be built, and I'm going to try to speed up here so I don't run out of time. A house that's going to be built up in the mountains, and both parties assume that there is a road that leads up to it, not necessarily a 4-lane highway, but some sort of access road to where they can get the construction equipment up there, the earth moving equipment, the heavy equipment. And then they enter into a contract on that assumption. They both assumed that it was accessible by road. And then they find out that there's not even a road up there. Well, that's a mutual mistake of fact. They both assumed a fact that it turned out not to be true. So the court can rescind or reform the contract because of their mutual mistake. Now, in the Sikora case, Your Honor, it was.
Well, how is that analogous to this case?
It's not.
Where there's no issue about accessibility. There's no issue.
Right.
I mean, in other words, we're talking here about whether somebody shows up for work and does the job that they've been asked to do and been contracted with to do, whether they do it in a workmanlike manner on a day-to-day basis. In other words, and they're performing the contract in a reasonable manner. I'm having a little concern here about the basis on which this came down.
Yeah, well, Your Honor, what we say is that the example I gave you is a classic example of an actual mutual mistake.
What's the actual mutual mistake here?
There isn't one. It's error. It was error. See, Your Honor, we're cross-appealing. Your Honor, let me apologize to you. It seems like I raised my voice at you, and I didn't mean to. So
no,
please.
I didn't take it. I didn't take it.
Thank you, Your Honor. But we're cross-appealing. We're not upholding the judge's decision at all. This is the judge committed a clear legal error by trying to rescind the contract and dismiss our motion, our breach of contract claim on the grounds of mutual mistake. There was no mutual mistake here. A mutual mistake is where they both thought there was a road and there wasn't a road. What he's saying is, I think it would have been better if you had agreed to a time of completion. That's not a mutual mistake because a time of completion clause is not required. Now,
is it a breach of contract to fail to show up for work on a timely and regular basis?
No, Your Honor. That an independent contractor can choose when and how he does his work. You can't say, now look, we're starting at 9 o'clock tomorrow morning. If you're not here, I'm firing you. A house painter can show up anytime he wants, as long as he gets the work done. And he was getting the work done when she terminated the contract. But remember, I'm not asking you all, you members of the Court of Appeals, to rule that he is entitled to damages for breach of contract. That's going to have to be done on remand. What I'm asking you to rule is that it was legal error to rescind this contract and dismiss our claim for breach of contract on the grounds of mutual mistake, because that's not a mutual mistake under the law. Now, I'm just about out of time, but
your argument is that he could not show up for work for a week or two and get nothing done, and that would not constitute a breach of what they agreed to.
Well, Your Honor, there's nothing in the record that shows that happened. But yes, an independent contractor sets his own hours. It's the way it works. He didn't not show up for a week or two, but that's not before the court. It's not before the court. You see, the judge's ruling did not make any findings like that. May I have 45 seconds to wrap up? Yes, Your Honor. No,
No.
go ahead.
No, I'm sorry, that your time's up.
May I have?
No, sir.
Okay. Okay. I
time's up.
apologize, Your Honor.
Time's up.
Thank you both. Thank you all three for your kind consideration.
Dr. Clark, you have 1 minute for rebuttal. Your audio's not on.
To begin with, I contend there can be no contract when there was intentional misrepresentation, but I would behoove you to look closely at the brief that I submitted. It is in the record that both Mr. Givens and I agree how long he was on the job. He was on the job 30 days, and we agree how much work he got done. I had a 3,000 square foot house, and he was supposed to paint the inside of the garage walls also. He never got past doing one coat on the loft upstairs and the sloppy job he did going down my stairwell. And he also was supposed to strip and prime my kitchen cabinets and bathroom cabinets. He did it incorrectly to where it all had to be redone. He used a satin finish that had to be replaced.
I mean, Dr. Clark, is there a transcript of the testimony in this trial?
Absolutely. I have all kinds of references that will help you immensely.
But in other words, did you have a court reporter transcribe the testimony at trial?
Yes, I paid $1,600 for it, sir.
All right, thank you. All right, thank you very much.
Thank you,
Thank you,
sir.
Your Honor.
We'll deliberate and give you our opinion in writing as soon as it's completed. Thank you so much.
Thank you very much, Your Honor. All three of you.
All righty.
This honorable court is now in recess until 2 p.m.
And we're out.
Counsel, you can.
During the hearing, Attorney Koppel was asked a question by Judge Armstrong that he was not able to adequately articulate in his opinion. And this is the attorney for Mr. Givens. So Attorney Koppel followed up with a response in the form of a letter to the three-judge panel. This isn't unheard of. There's oftentimes when questions are asked and the source or the prevailing law is not readily available, and research has to be done. A lot of law is research. So the attorney will go back to the office, they will prepare their brief, and they will submit it subsequently to the court. So that is what Mr. Koppel did here. He wrote a short letter to the panel, and he said, Judge Armstrong's question was as follows. In light of the holding in Custom Built Homes by Ed Harris v. McNamara, which was authored by Judge William Koch, would an owner have no remedy at all if the contractor simply failed to show up for work on the contracted project for as much as 2 weeks in a row? I believe at that time during the hearing, they were discussing whether him periodically showing up mattered because there was no time designation in the contract itself. The holding that we were relying on from Judge Koch's opinion in Custom Built Homes by Ed Harris v. McNamara was as follows, setting forth the only grounds for an owner's terminating a construction contract. A contracting party may terminate the contract by the other party, 1, when it wholly unable to complete the contract, 2, manifests an intent to abandon the contract, 3, manifests an intent to no longer be bound by the contract, 4, commits fraud on the party seeking to terminate the contract. When asked the question by Judge Harris, I simply answered that the owner would have some remedy. The correct answer is that if the contractor failed to show up to the project at the project site for 2 weeks in a row, the owner could then assert that there was manifesting an intent to abandon the contract, as provided for in number 2 of the Custom Built Homes opinion. It would be up to the trier of fact as to whether 2 weeks of absence from the job was long enough to manifest an intent to abandon the contract. 3 days, probably not enough. 2 weeks, probably enough, but it would be up to the trier of fact. This is the clear meaning of the holding and would provide protection to the independent contractor and to the owner. In this case, the trial judge in his written ruling made no mention of any of the facts relating to Mr. Givens' performance of the contract. His decision was entirely based on a finding that there had been a mutual mistake by the parties by not inserting a clear time of completion clause. As appellee, we entirely disagree with that legal holding and accordingly cross-appealed. Our grounds were explained. I thank the court for allowing me this means. The Court of Appeals issued its ruling about a week later. They provided a summary of the case, noting that all parties appealed. And as a result, the appeals court reversed the trials court decision and remanded for further proceedings. I'm going to try and go through this pretty quickly because it is very lengthy. They summarize everything, but they give a lot of details that weren't previously discussed in the hearings. One thing I'm not sure if I've really discussed before is the way that an appeals hearing works. Whenever you decide you're going to appeal a case, you notify the court that you're going to do that, but then you have a certain amount of time to file your brief. Your brief is pretty much what you stand on. That is the majority of the information. It has the factual background. It has all of your citations and all of the information they need. When you go to your hearing, the purpose of the hearing is not to rediscuss anything that you put in your brief, for the most part. It's in a lot of cases, an attorney will come up and say, I stand on my brief, or they won't even go to oral argument at all. A lot of attorneys aren't even approved to argue in front of, say, the Supreme Court. That is why you see the judges interrupting a lot and asking questions, because the primary purpose of that 15 minutes that they get is to clarify any issues that they thought might have been confusing or were kind of difficult to put into writing, or if anything has changed since the brief was filed, say a new opinion was issued that affects what was put in the brief, then they will provide that update to the panel at that point in time. I hope that makes sense. So for the facts and procedural history, this case is for an oral contract for construction services at a property owned by Miss Julie Clark, who is a veterinarian. While the events, date, and specifics of the agreement have been heavily disputed, our decision does not hinge on factual intricacies. After purchasing a new home, Dr. Clark searched for quality workers to make improvements on her current property before placing it up for sale on January 2016. She spoke to Wanda Givens, who owned a daycare where she took her grandson. Wanda indicated that her husband, Mr. Givens, could, quote, do anything she needed. So at some point, they met at her property and discussed the work. Mr. Givens started by performing some minor plumbing work, which he did to Dr. Clark's satisfaction, and he was paid for that. So Dr. Clark decided to have him proceed with other tasks, and in January of 2016, they met at the property, discussed the additional duties he would perform. They walked through the house, talking about the various improvements they would make, and they agreed that on January 14th, they technically formed an oral contract. And Mr. Givens was to paint the entire interior of the 3-story house, remove and repair kitchen cabinets, strip, prime, and paint the cabinets, and replace 2 bathroom countertops. So Dr. Clark claims that Mr. Givens gave her bids for each individual task for her to accept and pay for individually. She also claims that those 4 tasks were the only ones to which she agreed. According to Dr. Clark, the bids Mr. Givens gave her for the agreed upon tasks totaled $9,775. Mr. Givens, on the other hand, claims that they agreed for him to pressure wash the garage and driveway, paint the garage floor with epoxy. You don't paint with epoxy, by the way. You pour epoxy. It's kind of a self-leveling compound. Yeah, like a really thick glue. Then you gotta get the heat gun and get bubbles out. Sorry. Anyways, squirrel. And paint the outside porch and deck. He also contends that rather than making individual bids, he gave a simple quote of $11,575 for all of those tasks, including those that are disputed. The parties also disagree on the time of completion for the contract. According to Dr. Clark, Mr. Givens stated he would have the work complete in 2 weeks. That's a lot of work to get done in 2 weeks, but hey. While Dr. Clark said she didn't set an end date or that time was of the essence. Dr. Clark claims to have indicated she needed the work done in a timely manner. In contrast, Mr. Givens claims he estimated it would take between 4 and 6 weeks, but that he did not promise it would be done in that time. He testified he believed that there was no strict timeline and that he was afforded as much time as he needed to do a good job. So he received a $2,500 deposit and began working shortly after. Now, unbeknownst to Dr. Clark at the time of this contracting, Mr. Givens had suffered a significant physical injuries, ailments, had limitations as the result of a work-related injury. He lost almost all function in his left arm, wrist, and shoulder. So he pretty much was unable to use his left arm. He also suffered serious headaches and had trouble seeing out of his left eye. Those physical limitations left him unable to work significantly since the accident. When asked why he didn't tell Dr. Clark about his injuries, Mr. Givens responded because she didn't ask. And then later he admitted she would not have known about the injuries unless he told her, and that if he did, she would not have hired him. And I just want to interject, as someone with physical limitations, that is a huge project to take on. With those limitations, it's not just I can't use this arm. It's I have to overcompensate with my other arm, but I have to be careful because I can cause injury to my other arm by overcompensating with it. And it's taxing on your entire body. And there's so much more that goes into it. It doesn't seem right that he would take on a project of that size. So the following month in February, Dr. Clark returned to the property and found most of the work was still unfinished. There was only one coat of paint on approximately 1/3 of the interior, so she became upset at the lack of progress and what she believed was poor quality of work. She testified that Mr. Givens apologized and that she gave him one more week to make some progress, or else she would hire another painter. 6 days later, she went to the property and found no progress since her prior visit. So on the 9th of February, they met at the house. She indicated she was displeased with the work and she was going to hire someone else to finish the interior painting. So at that time, the parties agreed that Mr. Givens would complete the remaining jobs, including painting the doors and restoring the cabinets. Dr. Clark asserts that Mr. Givens was to complete his work to help earn the $4,500 that she had previously paid him. Mr. Givens disagrees. Instead, he testified that he agreed to complete the remaining jobs to help salvage the contract rather than abandon it. He asserts that the February 9th interaction was the first time Dr. Clark informed him of her frustrations and the intent to hire another party. At trial, there were varying accounts of when Dr. Clark hired replacement workers and when they began. One dispute involved Dr. Clark's son-in-law working on the property and performing work that Mr. Givens believed he was hired to perform. Lovely. So later, Dr. Clark spoke to Mrs. Givens and asked why she wasn't told about his injuries, and Mrs. Givens said, "I don't get into all that." So sometime in that same month, Dr. Clark filed suit against both Mr. and Mrs. Givens in the General Sessions Court of Dixon County. Dr. Clark asserted in her claim that she was owed a refund of $3,700 on the contract for services that were never completed. Mr. and Mrs. Givens filed the counterclaim for breach of contract, asserting the $4,500 in damages. The General Sessions Court found in favor of Mr. and Mrs. Givens, awarding them $5,075 in damages. Dr. Clark appealed to the circuit court. So General Sessions is a court below Judge Wolf's court. It's what we generally would refer to as a district court. After cases are heard in the district court, then they are appealed up to the circuit court, which is where Judge Wolf is in Dixon County. After her appeal from General Sessions, Dr. Clark amended her complaint to assert violations of the Tennessee Consumer Protection Act as grounds for recovery. In doing so, she argued that the Givens fraudulently misrepresented that Mr. Givens was capable and able-bodied, never once alluding to the fact that he was severely disabled, and she asked for treble damages under the TCPA that totaled $13,500. Now, the types of damages that can be awarded in a case are something we don't talk about very often because we don't play over in the tort world. We play over in the shackles and handcuffs world. However, there's 3 types of damages that can generally be awarded in a civil case. Where did that? You have economic and non-economic damages. These kind of comprise the compensatory damages side. And what these are is the damages actually suffered monetarily as a result of the loss of something generally tangible, something that's proven, medical expenses, damage to property, lost wages, replaced vehicle, things like that. There's also non-economic damages like pain, emotional distress, loss of quality of life that aren't quite black and white. Those are also intended to compensate the victim or the prevailing party for whatever loss that they suffered. The second type of damages is not meant to compensate, it's meant to punish, punitive damages. We've seen these get very excessive in some cases. The first case that pops in my head was the Sandy Hook, Alex Jones trial, where they awarded over $1 billion to the family in punitive damages alone. Now, under the umbrella of punitive damages is treble damages. It's a type of punitive damage, but it's not meant to punish the individual who is on the other side of the table. It's meant to dissuade others from committing the same offense down the road. By knowing that there is a statute that would allow damages to go up to a certain amount is supposed to be a deterrent. So what the statute in Tennessee says is that damages up to 3 times the amount of what is suffered can be ordered as treble damages. That is what Mrs. Clark is asking for here. The case was heard before the circuit court on May 7th, 2019, and all 3 parties testified. Then on August 21st, the trial court entered its final order. The court found that the oral contract lacked a time is of the essence clause, meaning that there was no date of completion, there was no discussion of the time frame of the contract, which was a mutual mistake on the part of the parties. Each of them contributed to the mistake, so the contract was rescinded. It was dismissed, all parties bore their own costs, everything was split evenly. You went home in the same condition you came in. Further, the court found that the reasonable value of the services rendered by Mr. Givens was $4,500, which was the amount that Dr. Clark had already paid him. So neither party was awarded any additional money. Section 2, the issues presented. Dr. Clark raises 4 issues on appeal, which we have reworded herein. The first is whether the trial court erred in not finding that the defendants intentionally misrepresented Mr. Givens' services, whether they gave undue deference to the defendant's testimony, resulting in it awarding them damages. 3, whether they erred in deciding not to apply the TCPA for the defendant's intentional misrepresentation. And 4, whether the trial court erred in denying the plaintiff proper compensation, including the treble damages and court costs. Mr. and Mrs. Givens presented 1 issue on their cross appeal, which they also reworded. In the absence of the time is of the essence clause, whether the trial court erred in dismissing the parties' claims and rescinding the oral contract for mutual mistake as to the time of completion. For the reasons stated herein, we reverse the circuit court's decision and remand. So the court's discussion of the case. Before we address our decision to this case, we assure Dr. Clark that as a pro se litigant, her arguments have been given fair consideration. Parties that decide to represent themselves are entitled to fair and equal treatment by the courts. The court should take into account that many pro se litigants have no legal training and little familiarity with the justice system. However, the courts must also be mindful of the boundary between the fairness to a pro se litigant and the unfairness to the pro se litigant's adversary. Thus, the courts must not excuse pro se litigants from complying with the same substantive and procedural rules that represented parties are expected to observe. Now, I'm going to skip over the citations in these, and if you would like them, they're obviously on the screen. I am going to post all of these documents over on Patreon so you can have access and law nerd out all you want if you care. So in contracts involving construction services like this one, failure to complete the project within the time frame for completion does not constitute a material breach of contract, absent the provision marked time is of the essence, which we talked about earlier. In general, the courts tend to assume that time is not of the essence in regards to construction contracts, because we all know they never get completed on time. So the scope of the court's review and this appeal pales in comparison to the multitude of issues presented to the trial court. As we previously stated, the trial court rescinded the contract due to the parties' disagreement on the time of completion. Generally, rescission is not favored by Tennessee courts. A court may not rescind a contract for mistake unless the mistake is innocent, mutual, and material to the transaction, and unless the complaint shows an injury. In its final order, the trial court summarily found that the parties' mistake was material. For our review, we find the trial court's decision to rescind the parties' oral contract and dismiss the case due to mutual mistake was a reversible error. The record doesn't show proof that there was any kind of time is of the essence clause discussed during their oral contract, which is the grounds in which the trial court rescinded the contract on. However, if you assume that that clause is not required to be in there, then taking it out does not make the contract fail on its own. It just makes it a normal construction contract that can take forever. In finding that the trial court erred in rescinding the contract, we are unable to address the remaining issues on appeal. Despite the trial court's repeated commentary that the case presents difficult questions of law and fact, it is the appropriate forum for determining the remaining issues of the case. As a result, we reverse the trial court's decision to rescind the construction contract and remand the instructions to make the necessary findings of the fact and conclusions of law on the parties' claims. We reverse the trial court's decision and remand for further proceedings. So I'm not sure if I explained that well, but not putting in that clause doesn't have an effect on it enough to make the contract not valid.
Good morning. My name is Dr. Julie Clark, and I would just like to say one quick thing before we get started. Being pro se is a obvious burden on my behalf, and all of this is new to me. It's like me trying to be a veterinarian for the first time. And it's a very different thing when you are pleading on behalf of someone else versus when you are pleading on behalf of yourself. And so I feel very passionate about this. And I also, because of that, I just want to, I had presented something that I wanted to present to you. And I felt like what was most important in my contention that this is a constitutional issue, that hearing what the defendants actually said was foremost importance.
Do you want to reserve some time for rebuttal?
Possibly. I can go ahead and do that. Yeah, I guess I can.
Okay.
I'm not sure that I will need to.
Okay. Well, usually people sort of say what they're going to do beforehand.
Well,
So, you can use it or not. It's up to you.
I'll go ahead and reserve it then.
Okay. How long?
3 minutes.
3 minutes. Okay.
Okay.
That means you have 12 minutes here.
Oh, okay. Though in that case, then I will not do it.
Okay.
Okay.
You want,
Excuse me,
You
sir.
want your full 15
I do
right
want my
off
full
the bat,
15.
and then Mr. Koppel will talk, and then that will be it.
That will be it. That's fine.
Okay. Thank you.
What I don't know quite how to proceed through this. What I was basically going to say is that I was improving 2 homes in 2015. And at that time, I found myself in the middle of a housing boom. And all the trustworthy contractors that I'd used when I first moved here in 2007, which was a completely different economic situation, were no longer available. My daughter, who was a teacher at Harpeth Middle School in Kingston Springs, told me about Mr. Givens because she'd seen him working at the school. And she recommended that next time I picked up my grandson, ask Mrs. Givens, who is the supervisor of the daycare at the school, if her husband did work for other people than just the school district. Well, because of what Mrs. Givens told me, I included her in this.
What did Miss Givens tell you?
Okay, she told me that her husband could do anything that I wanted him to do.
Okay.
And she listed off a few things, like he was licensed as an HVAC and he could do carpentry. Never once did she mention painting. But
So she didn't mention anything about painting.
no, but that is not the issue, Your Honor, if I may. The issue is that neither one of them told me that Mr. Givens was claiming to be disabled in a workers' compensation suit with Liberty Mutual over an injury at a previous job. And they were claiming that he was 100% disabled. And a mere 3.5 months before I asked her this, she told me that he could do anything that I could possibly want him to do, but she had told in her deposition, which I included in the court transcript, so I have it in the record, she said that he could only use his right arm when Mr. Huffaker.
What did Mr. Givens tell you about his ability to work?
Okay, let me quickly tell you that exactly why. Okay. When I asked Mr. Givens, he never said anything to me about it. He just said, he didn't say it at the time. He came over, I gave him a list of things that I was curious about doing, which was where Judge Wallace went on the mutual mistake. There was no mutual mistake. I had him bid on a few things. I said, let's start with the painting. It was a huge house. And I said, let's start with that. He said, oh, I'm a good painter. And then in testimony, he says, when his attorney asked him, where did you learn to paint? When I painted over my kids' coloring on the wall. He was not an accomplished painter. But that is not the issue. I had complete misrepresentation on the behalf of both of them. They're testifying in a workers' compensation suit that he's disabled and cannot work and ends up receiving $170,000 and being declared 70%, disability on some level. So he gets to my house. he doesn't do the job. I keep showing up and nothing's done. I ask him why, and then he starts telling me he's disabled. He says, I can't use my arm. I can't see good because I had a ganglionic block. And
So the misrepresentation is an omission, then, you're saying? That
Absolutely.
He didn't it's not something he said. He didn't say,
No.
I'm the best painter, I'm the,
well, he said he was an accomplished painter. Absolutely.
Okay,
He
so
did.
he says he's an accomplished painter.
Absolutely, yes.
All right, so he says he's an accomplished painter, but your primary focus with regard to the misrepresentation is he didn't tell you that he had physical limitations, which you're saying prevented him from being able
It
to
was
do the job.
material to the contract. I mean, if somebody is disabled and they can't complete the job because they're disabled, even his attorney said that he can't use his left arm, he can't grip and hold a paint can.
Now, the trial court judge in this case heard you, heard the Givenses testify, and essentially found everybody credible and said that you're all believable, you're telling the truth, that you're kind of talking past each other, but everybody's credible here. And so the trial judge says there was no misrepresentation that was made. And so for the core of your Tennessee Consumer Protection Act claim, you're saying there was this misrepresentation. In reviewing a determination from a trial court where there's a credibility finding and a factual finding, this court's review is more limited than a factual question. So what would you point us to in the record to overcome that finding from the trial court? Because the trial court is entitled to a great degree of deference in terms of those findings.
Can I read you a little bit? Well, I could point to the most blatant, damning thing. When I asked him, Mr. Givens, why he never told me that he was disabled, his response in the record is, ma'am, if I would have told you, you wouldn't have hired me. I mean, he goes on and on about his mentality, if I may project, is like, here's another thing. I asked him in the trial, do you remember ever mentioning to me that you ever had any problems from being injured at that time? His answer was, ma'am, you did not ask. And I said, but you don't remember mentioning it. He said, no, ma'am, I didn't offer it. No, ma'am, I did not, and you didn't ask. Like the burden was on me to discover that he was disabled. And he went on to say, so I asked him, I said, do you feel like your demeanor and the way you carry yourself appears to someone that doesn't know you as if you have a problem? Like if maybe you have a limp or anything like that. Do you feel like most people who would see you would think of you as an able-bodied person? And he said, possibly, yes. My daughter had seen him working at the school, and when I met him, he's a big, healthy guy. He did not look in any means to be disabled. And I actually gave him a job because I'd had so much trouble with contractors that I gave him a job to do with some plumbing. He handled it.
So he handled the first job, and he was clearly and successfully. I mean, that's the reason you hired him for the bigger job. And the trial judge, my understanding here, the trial judge looked at it and said, I think he could have finished the job, and that in this case that he was capable of having completed this job. What in the record would show that he wasn't capable of finishing this job?
So 30 days. That's how long he was there. I kept going over, nothing's happening. This is what he had not accomplished. It was a 3-story house. It had an upstairs, a middle stairs, and a basement, and he was also going to paint the inside of the garage walls. So after 30 days, this is what Mr. Koppel had not, sorry about that, Mr. Givens had not accomplished. First off, he'd only done a first coat of paint on the upstairs, which was a loft. It didn't even go the whole length of the house. So there was no second coat of paint on the upstairs loft, which included a recreation room, a very large master bedroom with 2 closets. the entire main floor, which had 17-foot ceilings. I asked him, how are you going to paint 17-foot ceilings with one arm? And he said, I'll just go up on the ladder, put my bucket on the ladder, and I'll roll it. And I'm like, you know, that could be a liability issue for me. So
Dr. Clark, didn't he reference also, though, using rollers with extension poles as part of how he was going to
with
paint?
one arm, Your Honor, with the paint sitting on the thing? What if he lost his balance? And that was actually part of the problem. When I first noticed there was a problem, I went over there, and when we got into the problem is when he was coming down the first stairwell. I looked up there and I said, what in heaven's name? It was all crooked. And I mean, I've owned several homes. I built a veterinary clinic. I know a fine line on a junction of the ceiling and the wall. And it was all over the place. He had paint on the floor. There was paint on my ceiling, which was not going to be painted. And I asked him why. Why was it like that? He said, well, I couldn't see out of my left eye. You know, it's related to the gangliotic block. I can't see well, and I was getting tired. I mean, this man is a liar. And that is the problem here. And the problem that I have with Judge Wallace is that my entire case, and I have built a case here, of misrepresentation. He said, if I told you the truth, you wouldn't have hired me. What can that be other than misrepresentation? Judge Wallace, in the first order, never once addressed my issues of intentional misrepresentation and my constitutional right to have access to the Tennessee Consumer Protection Act. Now, I know it's not a happy thing because I went and talked to several attorneys, and I was told, in fact, by Jack Garrett, the one that went to jail, that nobody will give you a ruling on a Consumer Protection Act. The one attorney I hired didn't know anything about it. He had to look it up for 20 minutes while I sat there. So I feel like I am being denied my access to a law that's on the books of Tennessee.
Dr. Clark, hasn't Judge Wallace, though, and you may disagree with the conclusion, and maybe it's a wrong conclusion, but it seems to me the trial judge said there was no misrepresentation here, that I believe that Mr. Givens and Miss Givens and you are all telling the truth, and that you're essentially just talking past each other here rather than somebody lying. And you know, maybe that's a wrong conclusion.
Well,
but isn't that a ruling on your Tennessee Consumer Protection Act claim when he says there is no misrepresentation that's
he may
occurred?
say that, but if somebody lies to you about a material factor, I mean, it's not like it was an accident. He knew he was disabled. He was in court saying he was 100% disabled. They say that he cannot do any work in the deposition. It's all in there. He says he cannot work. The judge asked him, it was Mr. Huffaker for Liberty Mutual asked her, what does your husband do all day? He sits around, visits his father, maybe brings me a drink, implying he cannot work. So you either are disabled or you're not disabled. You cannot be both. And I'm an educated person. I have hired lots of people. I've never had anybody hire me that I've hired later tell me that they're in a workers' compensation suit and they're telling that body in a testimony under oath that they cannot work, that they can't live more than 30 pounds. All of that is in there. There is just no way that this is not intentional misrepresentation. If it isn't, then I don't know what it would take for it to be intentional misrepresentation. There is a material fact. It wasn't like he was telling me his religious beliefs or something. This all pertained to his ability to do the work. And it wasn't done. 30 days. And he had not gotten off the first floor. He'd gotten down that one wall. There was still an entire main floor with 2 bedrooms, a bathroom, a kitchen, a dining room, a living room with 17-foot walls. There was an entire steep stairway going down to the basement where there were 2 bedrooms, a bathroom, there was an entire two-car garage that he had yet to paint in 30 days. How long does one supposed to give somebody to paint? When I hired a painter, it was done in a week. You know, he was attempting to do that job by himself, which in and of itself shows his lack of expertise.
Dr. Clark, is there testimony in the record that suggests that he had told you that it would take 6 weeks to complete? I understand you disagree with that, but does the record reflect that he testified that you had told him, he had told you that it would take him 6 weeks?
Absolutely not. I brought a piece of paper that is in the record that showed my notes. I'm a meticulous note writer. I've had to take records my entire life. In my notes, I said 2 weeks, and I had each job what he told me. And that's what Judge Wallace goes on saying, that there's this 2,000 disparity. In the notes, it says that I was asking about my garage floor because it was slippery and my grandson had slipped on it. I said, I want to put something down so the next family doesn't have their child slip on it. And he was telling me his opinions, and he said, if it'd be this, it'd be one thing, if it'd be another thing, it'd be another thing. But it said right on there, 2 weeks.
So you say he told you 6 weeks to do the painting?
No, he told me 2 weeks.
2 weeks. And
Yes.
then after 30 days, it wasn't even half done.
No, it wasn't even.
There's no way
It was
he
a
could have
fourth
even done
done.
it.
He hadn't even done the second coat on the upstairs loft.
Okay.
And so I gave him chances. I'm a nice person. I have 6 homeless people living with me. I gave him chances. I said, you know, he said, I promise I'll get it done. And I'd come back, not a dadgum thing would have been done. Not one thing. He wasn't even there.
Well, thank you. Your time is up.
Okay.
Mr. Koppel?
Good morning, Your Honors, and may it please the court. I am George Koppel, representing Mr. Givens. I want to stress at the beginning that this is a cross appeal. We are definitely appealing the judge's ruling. Now, this was a small oral construction contract that involved a lot of indoor painting and some other work, cabinet repairs, porch painting, deck and rails, outdoor deck and rail painting, pressure washing the garage floor, and pressure washing the driveway. The contract was entirely oral, and it was for $11,575. $4,500 was paid either at the beginning or during the course of the work, leaving a total of $7,075 unpaid plus prejudgment interest, and that's the amount of our claim. Now, Mr. Givens was entitled to that judgment because Ms. Clark breached the contract 3 times. She was not entitled to terminate the contract, and therefore her final termination of the contract was a breach of contract. He was entitled to the benefit of the bargain, and the benefit of the bargain was to be allowed to complete the job and to receive the $11,575 that he was entitled to.
So you must be saying there were no time limits.
That's correct. And the judge correctly found that they had not agreed to a time of completion clause. And that, Your Honor, is where I was going to go next. So let me move into what the judge actually did rule and what the law is on this subject. There was no time of completion clause, and it was an entirely oral contract. Now, it is not the case that there is no testimony that he said it would probably take 6 weeks. He absolutely said it would take 6 weeks, and he absolutely denied under oath at trial that he had ever agreed to anything like 2 weeks to paint a house that big and to do those other jobs. That's in the record. But the point is, the judge did not rule, and he was correct to conclude that there was no time of completion clause. Where he made a mistake is in ruling that you have to have a time of completion clause. You absolutely do not have to have a time of completion clause. And I think in the history of the United States, no 2 non-lawyers have ever had an oral agreement in which they agreed to a time of the essence clause. because they wouldn't know what that was and they wouldn't know the significance of it. So they obviously didn't have a time of the essence clause. Now, what is the law with regard to that? The law is that being late or slow in performance of construction work is not a material breach unless there is a time of the essence clause. She admitted under oath there was no time of the essence clause. That's in the record. And the judge correctly ruled that there was no time of the essence clause and no time of completion clause.
Counsel, you and
Yes.
Dr. Clark seem to be on the same page here in terms of the mutual mistake issue. That the trial judge erred here, and correct me if I'm wrong, but it seems like you're on the same page with regard to there wasn't a mutual mistake here in this case. I wonder, though, about the meeting of the minds language from the trial court. And essentially, don't we have ultimately a determination, and there's a more extensive discussion about mutual mistake.
Yeah.
But ultimately, didn't the trial judge just decide there really was no contract here, that there had never been a meeting of the minds, that your client thought this was one job for $11,500 or so. Dr. Clark thought it was multiple separate jobs, discrete jobs within that was for $2,000 less. And they just never got on the same page in terms of what their actual agreement was. So we really just don't have a contract.
Your Honor, I don't think that that is an appropriate conclusion from what happened here. I mean, he worked the whole time until she came in and said, you're off, you're fired, I'm terminating you. And there was not a dispute about the amount of the contract. There was not a dispute that it involved the things I just read out, various jobs, most of it was painting. And what the judge ruled was, incorrectly, and I will explain that, you said it's more than what the mutual mistake thing needs to be fleshed out a little bit. He ruled that not having an agreement on the time of completion was a mutual mistake. Now, I want to stress, before I talk about mutual mistake, I want to stress, the law of Tennessee is that it is not grounds to maintain breach, or it's not a material breach, if there is no time of the essence clause. That being late or slow is not grounds. And a lot of people might be surprised about that, but that's the law. You cannot go in and say, you are going so slow, you're fired, unless you have a time of the essence clause. And there's no doubt that they had no time of the essence clause. How many cases in Tennessee support that conclusion? 3, Madden Phillips Construction Company versus GGAT Development Corporation at 315 Southwest 3rd, 818. That is on page 15 of the brief. Also, Shepard versus Perkins Builders, 968 Southwest 2nd, a 1997 Court of Appeals opinion. Both of those are reported opinions. And finally, the Pews Lawn Landscaping case, 320 Southwest 3rd at page 252. That's a Supreme Court case, Tennessee Supreme Court 2010. So the problem with the judge's ruling is that what the judge felt, so now I'm going to talk about mutual mistake and why it's not a mutual mistake. Yes, Your Honor.
Did she fire him expressly because he was slow?
Yes.
Okay. She's also mentioned concerns about the way he was going about it could create liability. The way he was going about it wasn't professionally done, but it was none of that. It was just slow.
She so understressed that the judge didn't even make a ruling as to any defect in the work. And I want to also say, and this is not in the brief, but interestingly enough, the Court of Appeals, there's a good bit of Tennessee law in this area. Interesting. I didn't have to go outside of Tennessee at all. There's a Judge Koch opinion in which he says you have to give notice of the defects. You have to go out and say, you see this line here, it's crooked. I want you to fix that. And there's just nothing, there's no ruling by the judge of any defect in work. Her entire complaint was slow and not making enough progress.
Isn't the credibility determined the same way credibility may cause challenges for Tennessee Consumer Protection Act for Dr. Clark's claim here? Doesn't it also cause problems for you here in terms of the existence of this contract? And the trial judge said, I listened to everybody, they're all credible, they all are honest people just trying, and they're just not understanding each other. And Dr. Clark says this was a $9,500 contract that had separate subdivisions, and Mr. Givens says it isn't. I mean, isn't that enough in and of itself to just defeat the claim here that there was an actual contract?
But that's not what the judge ruled. The judge ruled that there was a mutual mistake, Your Honor. And in other words, that he may have said that, but the ruling was, I'm going to rescind the contract. Now, he rescinded the contract. He didn't say there was no contract. He rescinded the contract on the basis of mutual mistake. And that was a legal error. Now, what mutual mistake requires is that the parties have an assumption about the facts, a fact or facts that is incorrect. Specifically, parties, and this is from American jurisprudence, quoted on pages 10 and 11 of the brief, parties share a common assumption about a vital existing fact upon which they base their bargain, and that fact was false, or that assumption was false. And I'll give you an example. Out in California, where they build these houses up where they shouldn't build them because they get the forest fires and so forth, but they'll sometimes build a house up on top of a hill. Well, I guess you can do that in Tennessee too. And both parties assumed there was at least a roughed-in gravel road to the top of the hill. And they made the contract on that basis, and it turned out there was no road. They both didn't check it out. They both assumed there was a road. So it changes the whole scope of the job, and the contractor can't be expected to rough in a gravel road at great expense in order to build the house. And so that's a mutual mistake of fact. Not negotiating clearly to a time of completion is not a mistake of fact. It might be a good idea, but that's not the point. They didn't enter into a contract that had a time of completion.
Counsel, I want to read you part of the order here and set me right where I'm going wrong in my understanding of this. The court rules that there was never a meeting of the minds between Dr. Clark and Mr. Givens regarding the monetary contract terms and all the tasks to be performed. And that seems to defeat contract formation. That sentence alone seems to defeat contract formation. If there's not a meeting of the minds over the monetary contract terms and the tasks to be performed, what exactly do we have? How do we have a contract?
Well, Your Honor, I'm not sure that you understand that the court had already ruled in the previous case, and that's what makes this so very
I'm following that. I'm trying to look at this sentence in the order and see how that doesn't. I follow your argument with regard to mutual mistake, but it's and you and Dr. Clark on the same page with this, but this seems to me to tell me there's no actual contract here, and that there's a ruling that there's no meeting of the minds between Dr. Clark and Mr. Givens regarding the monetary contract terms and all the tasks to be performed. That sounds like there's no contract whatsoever.
But work was done, you see, and you have a contract can be formed, a unilateral contract can be formed. If you go out and paint my house, I'll pay you $11,000. And all he does is go out and paint the house. That forms a contract.
Isn't is $4,500 here that ultimately the trial judge decided this was worth the value of?
Yeah, of what he had already been paid. So he gets nothing.
Right. Isn't that consistent with the determination there was no contract? I mean, he gets the expenditures that he's had in terms of materials. He gets time for his work. I mean, the computation is consistent with the determination that there's no contract. I
don't think so. It was an $11,700 job, and he testified that he bid it on that basis because remember what happened. The first time she breached, she came out and she said, I've got a new son-in-law. I'm going to let him do the outside decks and porch and rails and so forth. You just do the inside painting. And he said, Ms. Clark, I didn't bid this job in that way. I bid the job because I needed, the profit that I got out of it was based on doing the whole task. And you're taking part of it away from me. But he kept on working. Sounds like, you know, I mean, how can we say that this is not a contract? So then she comes in, and she didn't come in. She sent a man over. Can you imagine this? She sent a man over there, and Mr. Givens says, "Who are you?" And he says, "Well, I'm here to finish the painting. You're apparently fired." She sent me over and said, "You finish the painting." And he was trying to, as I said in the brief, trying to make something out of this tattered contract by at least doing the cabinet repairs. And then she comes over finally and says, "No, you're fired." So she breached it 3 times, and she admits that he was not an employee. She admits that he was an independent contractor and that she terminated him unilaterally. Now, they had some sort of meeting of the minds there that he would continue, for example, with the cabinet work. He told her, he said, "Can I at least finish the cabinet work?" And she said, "Yes, go ahead." And then she breached that, 3rd time breach. So no, the only basis, I believe, for the judge's ruling was that he felt that they had made a mutual mistake because they hadn't been careful enough to agree on a time of completion. And the law of Tennessee, as the Court of Appeals from the Western Section ruled in the first case, that is not a mutual mistake. And there's no need for parties to have a time of completion clause. And there was no finding whatsoever that the 2 weeks was agreed to. She testified it was 2 weeks. He said, "I never agreed to any time, but I estimated for her that it would be 6 weeks." That's the testimony, and the judge didn't contradict that. And we do not claim that there was
any evidence in the record as to this painting job being that he told Dr. Clark this was going to be the greatest painting job that had ever been completed on the house? And what's the record going to reflect in terms of what Mr. Givens told Dr. Clark about the job in terms of the quality with which he was going to perform it?
You don't brag about painting a house like you do painting a portrait. He just told her he would do the job.
Right.
That's what he testified to. And he does have to paint with his right arm only, but you can dip the paintbrush or the roller into the paint and then do it with one arm, and that's what he was doing until she interfered with it and took that away from him. Well, I see my time is up. Thank you.
Thank you. Thank you both. And that completes the docket for the morning. Would you recess court, please?
Not long after that, the court issued its opinion. The first several pages of the document were identical to the prior ruling. It almost looks like they may have just copy and pasted the same information. Then it goes on that both parties appealed, following up in the timeline from after the prior hearing when the appeals court was involved. And these parties first appealed. This court concluded the trial court's decision to rescind the parties' oral agreement and dismiss the case due to a mutual mistake was a reversible error. This court reasoned that there was nothing in the contract to indicate time was of the essence and that any mistakes as to the time of completion was accordingly not material. This court remanded with instructions for the trial court to make findings of fact, conclusions of law on the remaining claims. Dr. Clark filed a petition to rehear, highlighting a typographical error which was corrected. The petition was denied insofar as it asserted that the opinion conflicted with the TCPA and it improperly omitted the act or improperly focused on the oral contract. On remand, the trial court referred the parties to mediation. Okay, this is information we didn't have because it was not in the docket notes, which was unsuccessful. The trial court entered an order after the unsuccessful mediation. The order was substantially similar to the 2019 order. However, instead of relying on mutual mistake as to the time of completion, the trial court relied on mutual mistake as to the material contract provisions, specifically the monetary terms, nearly a $2,000 difference, as well as the lack of agreement on all the tasks to be performed. The order elaborated that the court rules that there was never a meeting of the minds between Dr. Clark and Mr. Givens regarding the monetary contract terms and all the tasks to be performed. It further explicitly found that all the parties were credible and their observations and perceptions were just inconsistent with one another, that there had been no misrepresentation that occurred by any of the parties, and that the TCPA did not apply here because there were no misrepresentations. The court noted that Mr. Givens testified that he could have completed the task given more time, but that he was not permitted to do so. The trial court once more concluded that Mr. Givens was entitled to $4,500 for the work performed, essentially leaving the parties in the same positions they had occupied prior to the suit. The order again dismissed Ms. Givens from the suit. Dr. Clark, proceeding pro se, asserts various errors. She contends that the trial court erred in finding there was no misrepresentation, arguing that there were discrepancies between the Givens' statements, that Mr. Givens was capable of completing work, and their testimony in the workers' comp case regarding his severe disability. Dr. Clark also objects to the trial court's decision to credit Mr. Givens' testimony regarding the value of the work completed rather than relying on hers, which was based off contemporaneous notes. She argues that the trial court erred in rescinding the contract because Mr. Givens would not have been able to perform the work even if the parties had agreed on the terms. She also asserts that the TCPA applies to her claim and that the courts are abdicating their role and violating her due process rights by refusing to grant her relief under the TCPA. Mr. Givens responds that the contract was for a bid for the entire project, that it was not severable, and that he is entitled to damages for Dr. Clark's breach. He insists that the trial court rescinded the contract based on the parties' failure to agree on time for completion, and he focuses on arguing that the timing of completion was not a material term of the contract. In Section 2, the first paragraph is just a repeat from the prior ruling. Then it continues, Dr. Clark is proceeding pro se in this appeal. Dr. Clark was briefly represented by counsel below, but litigated pro se for the bulk of the proceedings, including an appeal before this court. Pro se litigants are entitled to fair and equal treatment by the courts, and a lot of citations telling you why they do that. Turning to Dr. Clark's arguments, we first address her challenges to the court's factual findings, pointing to inconsistencies between the testimony of the Givenses at trial and their deposition testimony. Dr. Clark asserts that the circuit court erred by failing to follow the rule of law, by finding that there was no misrepresentation. And what we understand as a related contention, she asserts that the trial court exhibited extreme bias and undue deference towards the testimony of Mr. Givens, as opposed to the testimony of Dr. Clark. On the issue of damages, both of these arguments amount to a challenge to the circuit court's credibility, determinations, and related factual findings. One of the most time-honored principles of appellate review is that the trial courts are best suited to determine the credibility of witnesses and to resolve factual disputes hinging on credibility determinations. As stated in the Tennessee Supreme Court, when it comes to live in-court witnesses, appellate courts should afford trial courts considerable deference when reviewing issues that hinge on the witness' credibility, because the trial courts are uniquely positioned to observe the demeanor and conduct of witnesses. In conducting a deferential view, a trial court's determination of credibility will not be overturned on appeal unless there is clear and convincing evidence to the contrary. In this case, Dr. Clark takes an issue with the circuit court's determination that their deposition testimony demonstrates that they were not credible witnesses. Dr. Clark further contends that the deposition testimony illustrates that the Givens' failure to disclose the injury was intentional misrepresentation. The circuit court, however, found that all parties testifying are credible, while the Givens' deposition testimony certainly stated that Mr. Givens' injury had prevented him from having a full-time job, and that his extremely limited use of his arm. Both Mr. and Mrs. Givens stated in their depositions that he was doing some carpentry work and other odd jobs. The record demonstrates that after the injury, Mr. Givens successfully built cabinets for the daycare, performed minor home repairs at Dr. Clark's new home, and did a good job of rerouting the plumbing for the bathtubs. Mr. Givens testified that painting was among the odd jobs he began to perform after the injury. The Givenses both testified at trial that they did not believe the injury rendered Mr. Givens unable to complete the work Dr. Clark was requesting. Insofar as there is any conflict between the Givens' trial testimony and their deposition testimony, the circuit court apparently found their trial testimony credible. An unfair or deceptive act or practice under the TCPA can include an omission, but the omission must be material. Both Mr. and Mrs. Givens testified Mr. Givens was capable of performing the work that he claimed to be able to perform. The trial court found Mr. and Mrs. Givens credible and concluded that there was no misrepresentation that he, in fact, could perform the work that he claimed he was able to perform. The record here does not provide clear and convincing evidence to contradict the court's credibility ruling upon which this determination stands, nor does the evidence preponderate against the trial court's factual findings. Under the facts of this case, we would be overstepping our role and improperly intruding into the province of the trial court by overturning its considered judgment and determining no material misrepresentation was made. We address Dr. Clark's TCPA claim in greater detail below. Great. Dr. Clark also objects that the trial court chose to credit Mr. Givens' testimony regarding damages, asserting that her testimony based on written notes should have been given more weight. However, there was evidence at trial, namely Mr. Givens' testimony, from which the court could have concluded that Mr. Givens had done more hours of work than that he charged at higher rates than was reflected in Dr. Clark's notes. The court chose to credit Mr. Givens over Dr. Clark after having seen the live testimony. As with the question of misrepresentation, based upon the record before us, we would be overstepping our role by second-guessing the considered determination reached by our trial court. Section 4, both parties assert error in the court's rescission of the contract. Dr. Givens contends the trial court erred by finding a mutual mistake based upon the absence of a time is of the essence provision in the parties' agreement. This issue was settled favorably for Mr. Givens in the first appeal. Mr. Givens is plainly incorrect, however, in his description of the trial court's ultimate ruling on the remand. The trial court's ruling on remand is responsive to the court's remand order. The circuit court stated, the court finds that the contract should be rescinded due to the mutual mistake of fact that Dr. Clark and Mr. Givens regarding the material contract provision, specifically the monetary terms, nearly $2,000 difference, as well as the lack of agreement on all the tasks to be performed. The court also based its decision on the determination that there was never a meeting of the minds between Dr. Clark and Mr. Givens regarding the monetary contract terms and all the tasks to be performed. Mr. Givens' contention that the trial court errantly ruled that a mutual mistake exists due to the absence of a time is of the essence provision simply does not appear anywhere in the trial court's final order on remand. Accordingly, we find Mr. Givens' argument to be without merit. Dr. Clark argues that there was no mutual mistake and that any mistake made by Mr. Givens as to the scope of work was not material because Mr. Givens was incapable of completing the work. We conclude that the circuit court did not err in concluding that the parties lacked an enforceable contract that permitted them to obtain the recovery they each sought. Even if we assume, arguendo, that the parties are correct that there was no mutual mistake in the present case to allow the contract rescission, the trial court still. Section 5, Dr. Clark argues that she was denied access to the TCPA in violation of the 14th Amendment, the Tennessee Constitution, the Code of Judicial Conduct, see U.S. Constitution Amendment 14, Section 1, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws. Tennessee Constitution, Article 1, Section 17, that all courts shall be open and every man for an injury done to him on his lands, goods, person, or reputation shall have remedy by due course of law and right and justice administered without sale, denial, or delay. Tennessee Supreme Court, Rule 10, Rules of Judicial Conduct 2.2, a judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. She alleges that the trial court violated these provisions by refusing to consider and harboring bias against the claims raised under the TCPA. Dr. Clark points to the fact that the circuit court did not make an explicit finding regarding the TCPA claim on its first order. Footnote 8, she also points to statements regarding the difficulty of bringing a TCPA claim allegedly made by attorneys she attempted to hire. These statements, purportedly made by unnamed attorneys, are not in evidence and accordingly not before us. However, any deficiency in the first order is not pertinent to our review, as the order was reversed and the case remanded to the court to make further findings of fact and conclusions of law. On remand, the court explicitly addressed the TCPA claim, concluding that the Tennessee Consumer Protection Act does not apply because the court finds there was no misrepresentation on the part of any party. Accordingly, Dr. Clark was not denied access to the court. She was able to present her TCPA claim, which the court considered and rejected based on the court's findings. The TCPA prohibits certain unfair and deceptive acts or practices affecting the conduct of trade or commerce, including representing that goods or services are of a particular standard, quality, or grade, or that goods are of a particular style or model if they are of another. In order to be successful under the TCPA, there must be a showing of some deception, misrepresentation, or unfairness regardless of a breach of contract. A material misrepresentation, practice, or omission likely to mislead reasonable consumers to their detriment. On appeal, Dr. Clark identifies 2 alleged misrepresentations that are the basis of her TCPA claim: that Mr. Givens was capable of completing the task at issue, and Mr. Givens was an inexperienced painter. However, as noted above, the circuit court explicitly found that there was no misrepresentation had occurred by any of the parties. They just didn't listen to each other. End of story. Where's my gavel? Pursuant to our analysis of the court's credibility determinations above, there was evidence, including the testimony that Mr. Givens was capable and the testimony that he had previously performed satisfactory work, from which the trier of fact could have found that the Givenses were credible when they said that Mr. Givens could do the work and had experience painting. Although Dr. Clark argues that the deposition testimony established that Mr. Givens was incapable of completing the work, any conflict between the Givens' deposition and trial testimony was resolved by the court in favor of the trial testimony. Because the statute only prohibits representing goods or services to be of a particular standard, quality, or grade when they are, in fact, of another, the trial court's finding that Mr. Givens, who testified he was able to complete the work, was credible sounds the death knell for Dr. Clark's TCPA claim. Dr. Clark does not list a request for attorney's fees in her statement of the issues, but she does request fees in the section of her brief entitled Additional Claims of Appellant. An issue may be deemed waived when it is argued in the brief, but is not designated as an issue in accordance with the Tennessee Rules of Appellate Procedure 27A4. In light of our resolution of the case, Dr. Clark is not in any event entitled to attorney's fees under the TCPA. Section 6. For the aforementioned reasons, we affirm the judgment of the Circuit Court for Dixon County. Cost of the appeal are taxed equally between the appellant, Julie Clark, and the appellee, Jeffrey Givens, for which execution may issue if necessary. In summary, that was a whole lot of hubbub about nothing. Like, y'all didn't listen to each other or know what you were doing. You were on different pages and it blew up in your face. The end. Bye. For real. Okay. I'm going to go not talk for a couple days. Y'all have a great one. I'll see you tomorrow.